I have two questions. I have quite a few questions, but I just want to leave room for the others to take the floor. First one. For the last 3 years, I've been reporting on the specialist chambers in almost 90% of the filings and motions, and from receiving any material evidence in 90% of the cases, the trial panel and now the preliminary procedure judge always have rendered decisions to the favor of the prosecution, thereby approving or upholding the prosecutor's motions. Based on the context I've had with different lawyers and experts, for them it is very surprising to see this major disbalance between the approved motions of the prosecution and then the defense. So having in mind this this statistic, I am convinced that it's over 90%. So how can we convey this principle of fair trial and fair treatment of the parties, equality of arms? And now the second item is the suspension of contacts and phone calls on 3 of the accused there. A credible institution with quite a budget, you do have capacities to establish mechanisms to prevent any actions or statements that may preclude or prevent the proper justice administration. But you took another action, the court took another action, which might be encroaching upon the rights to the visitation, to the family members' visits, and everything else. Would that be a violation on the other side?
Yeah.
To me.
Yeah.
Okay. Very good. Okay. Let us take the third question. Yes.
Faleminderit Jens Vëllon për televizorit të shtatë. Desha më lidh me një pyetje me kolegun tim për shkret e ushtrisë së Kosovës, që më thotë bëj shumë në procesin, në është një akuzë që nuk e keni më pasur deri sot, e kryetarët presidentit thotë
They don't hear you. The interpreters don't hear you.
Yeah.
Test.
Is the light on? Right?
Test.
Go ahead.
Sorry, what's your name?
Jens Vëllon.
Mr.
Jens Vëllon.
Gens. Mr. Gens.
Desha më ndërlidhje me pyetjen e kolegut për shkret të ÇK-s, është një akuzë që ende nuk ka drejtuar kërkohet me pyetje anonime në për shkretarët e presidentit thotë që ka deklaruar që jo kryetare e Gjykatës Speciale dhe ish prokurori në takimet me diplomatë kemi deklaruar që shkretarët e ÇK-s vetë se janë të dënuar tashmë procesi po bëhet vetëm sa për sy thotë. Është një pyetje jashtë procesit gjyqësor, por me të mund të merret përgjigje për këtë pyetje kësaj. Pyetja e dytë ka të bëjë me të arrestuarin britan Goxhaj, çka po ndodh tashmë të pas mos ekstradimit nga Gjykata e Shqipërisë në Gjykatën Speciale.
Okay, shall I respond to the three, and then we'll take it. So, thank you very much for these questions. And my answer. First, Mr. Kühne. I will start with the searches and seizures and their relation to transparency. I have been a prosecutor in youth. Thereafter, I was defense counsel. While investigation is ongoing, it is a confidential, not public, activity undertaken by any prosecutor on this planet, together with policemen, together with investigative officers. The searches and seizures are taken on the basis of thorough legal framework provided in the law for specialist chambers and also includes procedure and evidence. And I was just smiling. I know that it is not intentional, but the legal terminology is searches and seizures and not raids. No one is raiding anyone. That is how the world system of criminal justice is engaging in activities where some objects have to be seized that appear to be related to a crime that is investigated. So the searches and seizures are undertaken as a matter of principle by the Specialist Prosecutor's Office and his police officers as provided in the law after judicial authorization by a single judge. In case, however, that searches and seizures are necessary, for example, I always give as an example, if the policemen are chasing a drug dealer, of course they don't have the time to go to seize the judiciary asking for a seizure order, because in the meantime everything will be thrown into the toilet. So that's why the law provides, again, in any legal system, I believe no one will object to this, that in cases of urgency, this could be undertaken, these investigative actions could be undertaken on the basis of prosecution's order, and thereafter, if within 48 hours, our rules of procedure state, there is no judicial authorization, then the results of these searches and seizures cannot be used in any criminal trial. So, transparency cannot be there, because you are making void the whole purpose of this investigative activity. Then you are making reference to a witness whose whereabouts were not known. I have to say that it's possible. I don't know this, because let me make it clear. I know everything related to the cases what is public. I would never be given access to things that are confidential and that are pending before a judicial panel. So, I have not been following this particular witness, although in my office I have 3 screens, one with Outlook, then the material on which I'm working, and the third one, the courtroom. And when there is no private session or closed session, of course I'm following with interest, because these are important developments, just for my own sake as a lawyer and as a judge. I'm speculating now that maybe this witness has been under protection program. I'm speculating. I'm telling you, I don't know why this happened, and upon my return, Michael, do you know what happened to this? Yes. In full honesty, I'm telling you, I have not been privy to any information related to this witness. But as I said, it could be that the witness is under protection program. The witness has been relocated somewhere. That is all I can say. Michael, please, would you just give more information?
Maybe I can clarify what I understand the question is about, and if that's correct, then I would defer to you for the answer. Was it in relation to the witness in the Tachi et al. Trial who began the testimony, and then the testimony finished, and then adjourned the testimony until the following week, and then it was adjourned again, and there were no public filings about the reason why the witness. There was only a reference in the courtroom, an invocation of sanctions under the rules if a witness refuses to testify. So the public was not aware what had happened. Then subsequently, a public redacted version was issued of the judge's decision, in which they made it clear that that the assessment of the Witness Protection and Support Unit was that this witness was not at that time fit to testify, after seeing that that was the view of the psychologist, and that their testimony would be adjourned until sometime in the future when the trial panel determined that they were fit to testify. That's just to clarify.
Thank you very much for this background information. Here, I would like to just refer to our legal framework and what happens with other witnesses. That it happened that I was following, of course, such witnesses like 2 weeks ago, even last week as well. There were 2 witnesses. One of them was saying firmly, even if you're going to put me in jail, what actually the law provides, I'm not going to testify. So, there are witnesses, however, that during the time providing their testimony during the hearing, they feel vulnerable. We have within the witness protection unit, we have, apart from security officer, a lawyer, a language expert, we have psychologists. And then the judges would give a break, and the psychologist would work with this witness. And when the witness feels comfortable because, to testify further on, then he resumes his appearance and testimony before the court. So I believe that something, as you're describing to me, something along this line should have happened. And judges, of course, you might raise the question why the judges rendered a decision in several ways. Well, because they have to hear from the psychologist whether they're going to terminate at all and rely on the appearance of this witness on the prosecutor's list, or they will continue after the witness has feels comfortable to appear. So you wanted to clarify something that could be also useful to my response.
Nuk kam të nështë s'kam qenë I qartë. Nuk kërkova të më zbulua as dëshmitari, as një gjë tjetër. Kërkova gjyqtari. Proceduralisht më qenë ma transparent. Sepse në asnjë moment vetëm ka humb ai dhe ka fillu me dëshmitarin 30 pa tregu që ky dëshmitar do të vazhdojë në një periudhë caktuar apo një fjali vetme, asnjë se ka thënë. Dhe këtu për ky element po e vlerësoj që jo transparent. Edhe siç dihet dëshmitari së nëntë është pak specifik prej akuzave të polës mbrojtëse thashë se thotë ky dëshmitar ka lyp beneficione dhe kërkesës së tij të bërgoset që s'do të dëshmojë të bërgoset dhe këto kanë lind këto dyshimet tek kësaj mos transparence. Domethënë ne nuk kërkojmë u zbulu ai dëshmitar. Ne kërkojmë të thonë që dëshmitari 29 do të vazhdoj pasi do të zhvillohen do procedura, pa përmend qoftë edhe procedura, po hiç, vetëm ka vazhduar me disa dëshmitar tjetër pa u përmend më në asnjë moment të dëshmitari 29. Kur e dim që ky dëshmitar është pak më specifik.
Yeah. Mr. Kune, now let me tell you, and this is not anything to not respond to your question. You cannot, when a witness leaves, because the witness cannot continue to testify for whatever reasons. For example, there could be a scenario whereby the witness says, as was the case last week, I will go to jail, I will not continue testifying. Then a witness could appear extremely vulnerable, and then the psychologist who normally could sit next to the witness, because the psychologist work with the witnesses, the so-called familiarization before witnesses come and testify before the trial panel. Meaning they take them to the courtroom, they explain to them how the whole procedure will happen, appearing, you will sit here, you will be asked, you have to respond, and so on and so on. If you feel that you're not comfortable, just give a sign, and so on and so forth. There were witnesses that wanted to be shielded from a visual contact with some of the accused. So when you have witness who feels this way, a chamber cannot take immediate decision because I have to receive the feedback from the psychologist telling me whether this witness is capable to continue with his testimony. That is how it works. How do you expect that I sitting on the bench, someone feels uncomfortable and wants to interrupt the provision of the testimony? Thereafter, I'm going to issue immediately decision. That was not, I'm sure, just because that is how in the legal field things happen in real courtroom life. And you, of course, but you are right, because you could be suspicious that maybe some manipulations happen. Rest assured, with judges, this will never happen. Judges of the special chambers will never compromise the proper application of the law and the establishment of the truth. And in some time to come, we are going to meet, and I will not feel ashamed to face you telling me, actually, this is not true. But that is how it works. It's not possible. For example, what happened last week with Mr. Taci, Mr. Veseli, and Mr. Selimi, for whom an interim decision was taken by the judges, interim decision, to be segregated and also to be limited in their communication without any question, absolutely with their counsel, there is no doubt about this, and with some family members. But the judges issued, as they say, interim decision. Why? Because they wanted to receive a proper justification, meaning to provide facts and evidence from the specialist prosecutor who sees them with this urgent request, with this urgent motion, that is how it was named, then wanted to seek from the registrar whether organizations could be made, and will hear the defense as well. And back then, the judge made it very clear, giving the prosecutor 2 days for justification. The registrar thereafter 1 day. It was Tuesday, the registrar had to provide her views on Wednesday, and we're expecting any time. But such decisions are not taken lightly. I have to tell you, it's not possible. You know, a decision is not a decision if you don't provide reason. And that is the constant, because we have as authority the European Court for Human Rights, this is the constant jurisprudence of the European Court, that a judgment is not a judgment without reasoning, just making a statement and that's it. So the judges are taking very, very serious their responsibilities, and here I'm not to defend them. But I have to say that if I were them, I would do the same, just because we have to stand on solid grounds when we're taking our decisions. Now, thereafter, of course, you said that you can address a question. You have, of course, all the right to be suspicious if you do not immediately receive a feedback to your expectations. And that's why I'm explaining to you that regardless of best intentions, it's not always possible if you want to be a proper professional. Then Mr. Becher. Now, favoring the prosecutor. I cannot say whether the prosecutor has been favored or not. I can say only that equality of arms in the jurisprudence of the European Court for Human Rights means to provide the parties equal opportunities to engage in the decision-making process, meaning to be provided equal opportunities to provide their views, then to respond to the views of the opposite party, and then again give them the opportunity to respond, to make their findings, to present their evidence. If you're doubtful about the decisions, maybe you can refer to some decision, because this sounds very much worrisome when you're saying that 90% of the decisions are favoring the prosecutor. I have to say to the contrary. In the last weeks, Judge Smith, who is presiding over the big case, because I assume that your questions have been related to this case, he admonished the prosecutor's office by telling them, and the transcript will be public, to make clear that these to have as expeditious proceedings as possible. You're coming with 16 hours calculation that will take the questioning of your witness. Then we have only 3 hours, and we are losing the rest of the time. No, Judge Smith is just, and that is how it should be, of course. I have been always a very demanding presiding judge, because that is the expectation. Then Judge Smith was saying, if you cannot properly calculate the duration of the witness testimony, then you must organize your office to have a standby witness ready immediately to come to the courtroom if, because, of course, let us be fair, it's not always possible to be calculating with hours and minutes. No, because maybe I'm not clear. Yes, so you cannot, of course, be absolutely certain how much time. Initially, you calculate 16, but then it turns out to be 3. That's why this is the role of the judges. That's why we have quite extensively developed on the management of proceedings in the rules of procedure and evidence, which is the equivalent of a criminal procedure code in any domestic system. So you have to organize your office in such a way that we do not lose court time. That is my expectation. Stand by. Then, about the publicity of proceedings, which is related to the question of Mr. Kune, yes, Kune, and Mr. Becher, about also about transparency. Most of the time, I read that proceedings are not transparent because there are a lot of private sessions, and I'm excluded as well. I have the screen, private session, I see the judges, I see the witnesses, and that is all. However, as I was following to the extent that I can, quite often the defense counsel, and I will refer to Mr. Ben Emerson, an excellent lawyer, I have to say, when he was asked by the presiding judge, how shall we proceed? And he said, well, let us keep it private. So that's why I'm a little bit puzzled by what you say, because I didn't notice this. And let me finish on this point. You know, when we sit to take our decision, we have in front of us the submissions of the parties, and if there is a need, of course, some supporting material. We cannot take decisions going abruptly in favor of one of the parties. If we do this, we have to provide the reasoning why. For example, the motion was weak, was light, and we cannot just rule on this. So I would very, very much encourage Mr. Becher, if need be, to follow on YouTube channel what also provides a direct at a time which is good for people who are working. Everyone is very busy, so you just switch on the YouTube channel and just follow some proceedings. Then every week the Office of Public Information and Communication Unit, they give their press briefings, and you can address all these questions. And I have to say, I'm a little bit troubled about what you said, because my expectation was different, that judges are quite demanding vis-a-vis the stronger party, and the stronger party is the Specialist Prosecutor's Office, and any prosecutor on this planet. That is the stronger party. That's why the defense has to be given also all opportunities, and that's why when there is a question how long this trial will last, it is voluminous, complicated, with 4 accused, and after the prosecutor finishes his case, we don't know how much evidence the 4 defense teams are going to present. But again, and I will finish on this because I see you're impatient, rightly so, sometimes in my willingness to be exhaustive, I could speak a lot, but that is my field. That is my field. That is what I do all my life. So one last point with regard to the performance of, in particular, the trial panel big case. Judge Smith also was demanding since the 16th of December last year, because let me open up brackets to tell you what I did. I already have considered, in case the pretrial judge will send the case to trial, and I asked colleagues to start reading the public filings so that they get to know the case and so on, so that they don't lose time. Because sometimes it takes months, sometimes a year, for the trial panel to get to know a case which is such a delay in the development of the proceedings. That's why on the 16th, the judges demanded from the prosecutor, of course, because he's the driving force, demanded saying that if there are repetitive witnesses, because the number of witnesses was over 320, you have to put effort and to, on one, for example, element of the crime, you have 10 witnesses, 20 witnesses. Choose the best. And you have to abandon the rest. Just because we are not going to keep this trial ongoing forever. Now, I will give you the floor just to say about Mr. Gaines. You said about Mr. Jack Smith saying that it's a decision made.
The advisors said that you and Mr. Jack Smith, when you meet the diplomats, you say that the big case are already arrested. I mean, already detention.
Well,
but it's a speculation. But it's a speculation that you did not give an answer to till now. So
well, first of all, it's highly unprofessional. No one who pretends to have had all his career in the judicial profession would say anything of this kind. Second, just to tell you, on institutional matters, there are meetings with the registrar every day. We are the Kosova Special Registry chambers. With the prosecutor, I need to have meetings, and I shall tell you when. When the prosecutor is considering already to seize the chambers with, for example, an arrest warrant or indictment. Our judges, and that's why everything has to be seen in the context of the design of our institution. We are all on a roster, except for me for the time being. And judges work elsewhere. And I cannot lose so much time. We are very, very much ambitious to respect the principle of expeditiousness. I told the prosecutor, Mr. Prosecutor, and of course, rest assured, I always address him, Mr. Prosecutor, as now I address Miss Kim West, Madam Prosecutor. We don't have any close relations, and that is how it should be. They're even in a different building. We're not even under one and the same roof. I told him, Mr. Prosecutor, I don't want to lose time. Our judges on the roster, they have their business, either they're judges in their domestic systems, prosecutors, university professors, and so on. Notify me in advance, because I want the minute when you're going to seize chambers, the case that I already would have discussed with my colleagues who is available, who is not available, who is willing. There could be cases of contamination. For example, judges who have been sitting at another institution, for example, the ICTY, UNMICT, or here in Kosovo, that could have been dealing with similar crimes or with the same crimes or with the same situation. So that is my communication with the prosecutor. How, and I have to say, this was a very unfortunate comment that was made back then. First of all, when we are invited to a diplomatic briefing, for example, when we have, apart from I cannot dictate to the host to tell them, I will not come if this man is going to be here. I sit distant from him and we do not communicate because his business is not my business. Who is going to believe a judge if the judge is in close relations with the prosecutor, whoever the prosecutor is? So that is number one. Number two, when we have these before New Year celebration, we are going to the registrar, our registrar, just to have some drinks, some bits and pieces. Everyone, for example, like very much to make burek, and I bring it as well. So, and then, do you know who is invited? Chambers are invited, the prosecutor is invited, the staff, and the defense. And the defense are speaking out for the holiday, for how they work, how they appreciate, and so on and so forth. And that is always the case. And that should be the case. That is nothing to be praised about. So, back then, when we have been invited, I'm not sure whether it was online or it was in person. I don't remember this. It was around the pandemic period. The diplomats had to discuss a question. I know the issue because I was approached by the diplomat, the ambassador who invited me, telling me, time will you need, because thereafter we have to discuss this and this question, which was a confidential one, having nothing to do with us. Nothing to do with us. A common support for a candidate of the European Union. So we had nothing to do with this. And then I remember that there was my presentation, nothing confidential in my presentation, I can give you this presentation as well, was circulated to all UN member states. And the people asked for the withdrawal because, for example, Kuala Lumpur, what do they have to do with my presentations? They don't know about my existence. And there was a call from a journalist, maybe that was you, Mr. Becha? There was a call, whether this has to be kept confidential and so on. And initially I said, if it is related to me, I never speak confidential things. I'm open. What is confidential, I cannot communicate to anyone. But actually, finally, it was decided because of the issue discussed thereafter about this joint agreement on an important person, not person, a position. And you cannot imagine how much I regret. Because thereafter, I read in the press anything that could be a speculation. But I have to tell you, do you know what is important about myself? I know that we are not doing anything wrong, anything confidential, anything political, anything behind the scenes. And I cannot stop I cannot stop people from making comments. That is the right of everyone. That's why it's very important that we meet, that we exchange, that we discuss. And that's why I'm here to respond to all questions that you may have. So, and Mr. Goksai. So, Mr. Goksai, on the 1st of January, he did exactly what Mr. Gutsati and Mr. Haradinaj did. He just publicly disclosed the names of protected witnesses. Mr. Becha, I'm sorry, I will give you the floor just in a minute. Yes. So, Mr. Goksai, as far as the public filings tell us, was warned not to do this. He said that, no, I will disclose the names of hundreds more and so on and so forth. So, obviously, this behavior of Mr. Goksai led to the arrest. Thereafter, it was confirmed because there is an extradition agreement between Albania and Kosovo. The basic court decided in favor. Thereafter, he appealed, and the appeals court, till now, the appeals court didn't provide a reasoning. But the appeals court decided to release, and that is how it is. So that is the response to your question. So, Mr. Becha, finally, you have the floor.
Fillimisht për shkak të pyetjes dytë sepse nuk u përgjigjet në lidhje me ndalimin e vizitave. Ju keni mekanizma të fuqishëm që me kontrollu se cilin komunikim nëse pretendoni që po shihet drejtësia, por adresoni që nuk do duhet që në këmbim të ruajtjes së procesit të drejtë pastaj të shihet një drejtë tjetër që është e drejtë elementare si ajo për vizitë. Edhe pasi thatë që është blenguese procesin e vendimeve, unë vetëm me kujtesi kam disa prej tyre, për shembull, në fillim prokuroria ka kërkuar një vit kohë për me u përgatitur për rastin. Kjo është lejuar nga gjyqtari i procedurës paraprake, më pas ka zgjat 3 vjet dhe nuk është e ka pasur ndonjë konsekuencë në lidhje me këtë banesë. Kemi për shembull është refuzuar mundësia e lirimit nga qendra paraburgimit, është refuzuar në arrest shtëpiak, është refuzuar lirimi në vendin e tretë. E kemi rastin kur është plotësuar akuza për shembull me Budakovën dhe Gjilanin, gjyqtari i procedurës paraprake e ka aprovuar gjithashtu kërkesën e prokurorisë, në anën tjetër e ka refuzuar të mbrojtjes. Kemi një kërkesë të mbrojtjes së faqit që është refuzuar, që disa dëshmitarë ndërkombëtar për shkak të moshës të dëshmojnë më herët sepse mund të vdesin. I kemi për shembull mbrojtja e Veselit ka kërkuar që të largohet një provë materiale nga rasti i Fred Abrahams, edhe kjo është refuzuar. Gjithashtu është shkuar deri në gjykatën kushtetuese çështja e provave nga Serbia, edhe kjo është refuzuar. Është refuzuar gjithashtu gjitha ankesat që kanë pasur bëjnë me shkeljen e të drejtave të njeriut deri te avokati i popullit. Janë vetëm këto disa nga vendimet kryesore që unë mbaj mend që janë marrë dhe nuk ka pasur një disbalans në vendime bazuar në ato që ka ligjë prokuroria dhe mbrojtja.
Mr. Becker, you understand that as a judge who will be sitting on these cases, I cannot comment on the judgments of my colleagues. They render the judgments. However, let me tell you, first of all, the pretrial judge does not question witnesses. Witnesses do not appear before him. It is only for the trial panel that is already dealing with the subject matter of the case. So, but you referred to something that was rejected by the pretrial judge about aging witnesses who might not be there. So, well, then the Constitutional Court chamber, you might agree and disagree. Others might have a different view. What matters is that we start reading a judgment without having a predetermination what we want to read in the judgment, what the outcome should be. It is very, very important, but sometimes it's difficult. Just with open mind to try to see what is the subject matter of the judgment and then to see whether there is a proper, good, convincing reasoning that is provided in the judgment.
I just want to answer about the second questions for the visit and the communication.
Yes, the visit, yes, the visits, and I didn't reflect the mechanism, but I can speak a lot about the mechanism, and rest assured I will tell you everything that you expect from me. Now, about the conditions, I think that I have explained that trial panel 2 in the big case is expected to come with a final decision on this urgent motion from the prosecutor about limiting communications of the three accused, Mr. Taci, Veseli, and Selimi, having received the views of those, the prosecutor, the registrar, and most likely the defense, of course, and let us see what they will decide. But as I said, it is imperative that the meetings with their council cannot at all be limited, and this is a free meeting without any monitoring. This is the sacred relationship between a client and his counsel. With regard to family members as well, the judges will decide upon the suggestion whom of the close family every one of the three accused would like to have constant visits and meetings. That will be done. But I'm sorry, Mr. Becher, you're a little bit one-sided. Don't you see that on the one side, we have the interest of private life, and I explained to you what was in this interim decision by the trial panel. On the other side, the names of protected witnesses, the names of protected victims. That is what the judges said. Then the integrity of the proceedings. As Judge Smith said when he was delivering the judgment in the Mr. Guzzati and Mr. Haradinaj case, he said, the appearance of witnesses gives us the fundamentals of the justice system in any country that cherishes the rule of law. So I'm sorry, but I have to tell you my impression that we have to see the balancing approach. They will not be deprived of visits. They will not be deprived at all of discussions with their counsel. They will be provided with the most important documents immediately translated into Albanian. Let us see what the judgment will be. But we shouldn't forget about witnesses. Any one of us could end up in this position when we have been privy to a crime that was committed. This is a civic duty to appear and to speak out so that at the end justice will be done. So we cannot just disregard them and say, well, we're not interested, you could be intimidated, you could be killed, you could be... So judges have to take, and I have to tell you as a judge, I myself, the minute I used to receive the cases when I was at the ICC, the whole responsibility for the protection comes over us, over the judges of the chamber. We were called chamber. And you cannot imagine how much attentive we were to the protection of. For example, in one case, I was in the courtroom, the witness was already in the air. Our special person from the registry, very experienced lawyer, he came to me and said, can I just ask you, I just stopped the hearing for a minute, and he told me, well, the witness of yesterday is in the air. His family notify us that there are threats to put on fire his home and to kill his family. So, of course, I immediately gave a break, I sat down together with him, and we engaged with protective measures. This is a serious matter. This is not anything against this one in favor of someone else. That's why the profession, the judicial profession, is so fascinating. It's so very interesting because you can never predict what will come to you every single day. And with wisdom, honesty, professionalism, we have to handle this. And this doesn't mean that we are biased. No. I hope that I responded to you. Now about the mechanism, Mr. Becha. This issue was raised by the Speaker of the Parliament, Mr. Kunjuvka, and it was raised by the Minister of Justice. The Speaker of the Parliament, Mr. Kunjuvka, raised the issue of oversight mechanism for us. It was also repeated by the Minister of Justice, a very, very nice Miss Abdulena. I cannot, Hadjiu, yes. I met her on a number of occasions. I'm going to meet tomorrow to have a meeting in the Ministry of Justice. If she's busy, I will meet the deputy. They came to The Hague as well. We had very nice meetings. And this issue was raised last year, again, in May, June, July, September, and January this year. And I'm quoting these months, Mr. Becha, in order to give you proofs that these matters are taken seriously. What is the purpose of an oversight mechanism? As the Minister of Justice, in her recent communication, explained, to protect the rights and fundamental freedoms of those that are brought to account. And here my response is that the whole structure in the specialist chambers, it mirrors the structure of the judiciary here in Kosovo. the decision of the single judge, the decision of the pretrial judge and the basic court, they belong to the basic court, is always subject to the appeal before an appeals chamber. Thereafter, it's subject to the appeal before the subject to a referral to the Supreme Court chamber. Finally, subject to a referral to the constitutional specialist chamber of the Constitutional Court. Do you believe that all these judges are going to be dependent? No one of the judges with the specialist chambers is dependent on anything else but what we were sworn in, to do our job honestly, conscientiously, independently. And the appeals chamber will review the decision of the basic court. The Supreme Court will review the decision of the appeals and the specialist chamber of the Constitutional Court. Next. We have the totally independent office of the ombudsperson. Mr. Spera is an Italian judge who has been elected to the position of an ombudsperson, and he's totally independent. He has the right to immediately, whenever he wishes to do so, to go to the detention center, to speak to the detainees, to provide reports. And by the way, I have to tell you that all his reports, first of all, Mr. Spera provides on the website of the KSC a summary of the complaints. But here I open up brackets to say something that is not related directly to my point, that he used to receive, because once a year, if he comes, he passes by my office to meet me, and he said that he was very much impressed that a lot of Kosovo citizens have been appealing to him on issues that do not at all fall under the subject matter of our cases. For example, about some bills, some injustice that was done to them. Of course, he cannot deal with this, but he very politely responds to these people. So we have also the International Committee of the Red Cross. And the International Committee of the Red Cross is a traditional, well-acknowledged organization that is the most independent entity on this planet. They have the right to come again to the detention facility. Even if they want, they may come at night without informing anyone, without seeking authorization from anyone. And of course, they provide thereafter, they prepare their reports, and if there are some wrongdoings, they're communicated to me and to the relevant chamber or to the specialist prosecutor's office. Then, the specialist chambers has the Code of Judicial Ethics for Judges. And as I said, in the rules of procedure and evidence, we were very, very much demanding to ourselves not to delay proceedings. The same was the case, is the case with the Code of Judicial Ethics, because there are principles that judges have to abide by. And if these principles are in some way breached or a judge is misbehaving, the judge could be subject to disciplinary proceedings, ending up with a sanction that could be removal from the roster. Of course, here, you have to be, I have to inform you that that decision could be taken only by the plenary of judges, which is very important, not by any political entity, not by anyone else. That is how we ensure the independence of the judges. Then the selection of the judges. No one has been appointed. Judges who wanted to apply to be judges on the roster of the specialist chambers only received the support of their countries, meaning that they satisfy, there is the assertion on behalf of be it the judicial council of the country or the Minister of Justice, that they satisfy the requirements that are announced in the call for nomination of judges, so that someone doesn't come having 1 day of experience and applies. Then we have been appearing, because I was one, every judge, including myself, we applied and we appeared before the independent selection panel, comprised of international judges. They don't have any agenda. and they're not remunerated for anything. And this is an exam. And lastly, very importantly, and even I have been invited to make a study on the election of judges with other institutions because there are a lot of problems. That was organized by the Open Society in Washington because the way our judges are selected gives very strong hopes for merits, that they're elected on the basis of merits and independence. What I mean by this? First of all, one country could support as many as good candidates are willing to be put on the roster. For example, I will not name the country. During the selection process in 2016 when I applied, one country supported 17 excellent lawyers who wanted to be judges. Then the selection panel does not confine itself only to one judge from one country, which, for example, is the case before the ICC. I was the only nomination from my country, and I was nominated by the traditional Union of Bulgarian Lawyers, traditional for ages. So, thus we end up with judges that have proven their professionalism, their competence, they have reputation that is not compromised in any of the activities that they have been involved in, and this gives a very, very strong assurance up until now that judges are not subject to any influence, because there is a question all the time, political pressure. Now, up until now, it has never happened. Anyone to dare to try to put political pressure on anyone, including myself, starting with myself, and also my colleagues. Never. And this is to the credit of the authorities of Kosovo and our stakeholders, who are member states of the European Union and contributing states. Never. And it will stay like this. And I say, not to our credit, to their credit. Our credit is a given. We can't be judges if we are corrupt. We can't be judges if we are not delivering justice. That is it. So that's why that is my response about the mechanism.
I think we had a question. I think.
Yes, the lady, I'm sorry, what is your name?
Rina Mujko from Kosova delegation. And I am
Rina?
Rina, yes.
Rina, thank you, Rina.
I am continuing in Albanian as well. I'm continuing in Albanian.
In Albanian. Okay, thank you. I will, yes. Yeah.
Po filloj me kritikët të fundit që përmendët zonja kryetare.
A little bit slow.
Yeah.
I don't see translation.
Yeah, I don't hear.
Interpretation.
Është mirë?
Go ahead and try. Go ahead.
Po filloj me kritikët të fundit, çështjen e fundit të cilët përmendët, që nuk do të ketë asnjë mundësi që të ketë ndërhyrje apo presion politik. A ka pasur deri tash zonja që nga fillova nga ndonjë shtet, qoftë edhe nga Kosova, ndonjë presion politik, më qenë se përmendet apo jo. Kjo është pyetja ime e parë. Pyetja e dytë. E dim, do të thotë është bërë publike tek javën e kaluar arsyeja e ndalesave të vizitave dhe komunikimeve, që janë të përhapja e informacioneve konfidenciale nga brenda burgut, si dhe përmendja e dëshmitarëve të mbrojtur, por ende nuk e dim, po besoj që nëse ka ndonjë rast të madh ose të jashtëzakonshëm edhe pa pasur ndonjë vendim, ju do duhet ta dini deri tash nëse ndonjëri nga këta dëshmitarë, emri i të cilit është përmendur brenda burgut, ka pësuar ndonjë kërcënim apo diçka nga ndonjë palë tretë për shkak se është përmendur emri, për shkak që çdo shkak do ta ketë edhe pasojën, edhe po besoj që vendimi do të merret në meritat e kësaj, mirë po jemi kurioz të dim nëse ka pasur ndonjë dëshmitar që ka pësuar diçka apo janë thjesht pretendime të prokurorisë specializuar. Tjetra është shqetësim të jetë i madh kohëzgjatja e gjykimit. Pra që pritet që ndodh edhe që përfundoj krejt ky gjykim. E kam fjalën pikërisht për rastin e madh, sikur se i referoheni edhe ju thaqën dhe të tjerët, dhe përmendet fuzionimin e dëshmitarëve. Në një rast, nëse ka 20 dëshmitar, juve i keni biseduar me prokurorinë që ta sjellin njërin që është më kryesore. Cila është përgjigjja e prokurorisë?
Not me.
Not you.
Not me, the presiding judge, Judge Charles Smith. I can't. In what capacity shall I talk to the prosecutor?
Ka akoma ndonjë përgjigje rreth kësaj, edhe cila do të ishte rruga që do duhej ta ndiqte prokuroria në këtë rast për ta minimizuar kohën. E pam një protest para se ju ta nisnit këtë konferencë. Dhomat e specializuara të Kosovës vazhdimisht dalin me komunikata dhe me njoftime se besueshmëria e qytetarëve në këtë gjykatë është tejet e lartë, por akoma asnjëherë nuk ka ndryshuar diçka dhe nuk lejohet ndonjë organizatë vendore e Kosovës që ta monitorojë gjykatën speciale, duke qenë se Këshilli Gjyqësor i Kosovës nuk ka të drejtë ta bëjë këtë, ose kuvendi i Kosovës apo dikush tjetër. Ju keni thënë se askush nuk mund të pikëqyr gjykatën speciale. A do të ndryshoj kjo ndonjëherë për shkak të gjithë ngjarjeve që po i shohim deri tash? Dhe një pyetje tjetër për cilën juve nuk keni komentuar akoma, Sali Mustafës në dhjetorin e kaluar ju janë dhënë 26 vjet burg, jashtë çdo ligji, sipas gjithë juristëve, jashtë çdo ligji aktual dhe të mëparshëm. Edhe si kryetare e kësaj gjykate, por edhe si një gjyqtare me përvojë të gjatë, si e shihni këtë? Pra, një vendim, një gjykim me 26 vjet. Ne po presim apelin e këtij vendimi, mirë po ai vetë është gjykuar me 26 vjet. Sa është e drejtë kjo? Vërtet, sa është e drejtë? Kaq për tash.
Rina, you asked a lot of questions. Can I first respond to Rina, thereafter to you? Now, interference, never. Let someone come and prove me wrong. There was never any pressure, any interference in what we do. We are guided by the law and the facts of the case. That is it, and I assert this for all colleagues, for all judges. I'm not defending them. You have to rest assured that I'm very, very attentive to when I observe, because it's interesting for me, it's important. When I meet you, it's good to have answers based on my personal impression of how the hearing is unfolds. On this, I'm absolutely, firmly certain. There is no interference. Rest assured about this. Then, the witnesses. Of course, you rightly so said that most likely this is confidential. I know everything that is public. I'm not someone to, and there is in no legal system, the president of the court could be meddling and interfering, what was your first question, into the work of other judges. That is out of the question. First of all, out of the question for me, because I was sworn in to be independent and also to respect the independence of others. And I would never allow that someone intervenes into my independence. So we have normal collegial relations when we work, most of us work remotely, so we don't know each other so very well. But I cannot have any information beyond what is public. Most likely, the prosecutor now, in what he was asked to communicate to the trial panel dealing with the case, is going to provide some information, most likely. Because for the panel to take a final decision, not this interim decision, it has to have facts. So, but I believe that up until these people remain with this confidential status, the judges are going, you know what we do? We issue, publicity is the principle. Decisions have to be public. However, for reasons that we all know, protection, we have also the system of reductions. But the judges, in order to inform everyone who is interested in what we do, also issues public redacted version. So just the names of the witnesses will most likely be redacted up until such time when it will be safe for them. So.
Did the SPO provide you with new charges?
No, and they're not provided to me. The SPO will inform me in order to, yes, well, so far not. Of course, you are right, but I cannot, if there would have been a case, the prosecutor will inform me 2-3 days before seizing the chambers in order for me to seek the availability of my colleagues. That is all. Even I don't know what the charges are, in what case, against whom. I will seize you with a case where the judges have to be 3 permanent and 1 reserve judge. So that is how it is. Then, the protests. I didn't very well understand.
Oversight from the assembly, whether the situation, whether the assembly could ever.
Whether from the assembly or any organization from Kosovo that can monitor and oversee
well,
the job in Kosovo specialist chambers, but at the detention facility.
Well, let me tell you. First of all, the reference to the Supreme Judicial Council. The Supreme Judicial Council has the functions that are exactly the ones that I was referring to, with the disciplinary proceedings that could take place if judges are breaching confidentiality, if they try to intervene into the work of their colleagues to inappropriately influence the outcome. So the Code of Judicial Ethics is on the website. Even it was taken as a good model for a big project for international criminal judges for ethical principles. And of course, I was very pleased because we have a very, very robust system of accountability for judges. So, what do you think? Why should the government or the parliament establish such? Why? So this means that we don't trust that a decision that was taken by the basic court is going to be properly reviewed by appeals judges, thereafter by supreme judges, by specialist chamber judges.
We have the Court of Appeal and the Supreme Court.
Yes. Yes. Yes.
We have the Court of Appeals and the Supreme Court, even in Kosovo.
Yes, of course, we follow the system.
Yeah, but we still have a Kosovo Judicial Council who monitors the work of the courts in Kosovo. But the Kosovo Judicial Council does not monitor the work at the Kosovo Specialist Chamber. So that's why I'm asking if there is needed, first, it's being requested, another mechanism to monitor and oversight the work.
Well, actually, the Kosovo Judicial Council does not monitor how the decision was taken. That is impossible. There is no country cherishing the rule of law where the decision-making is going to be monitored. Then we're not talking about justice. Every judicial council in every country is monitoring the appropriate behavior of the judges, whether the judges are abusing some standards of judicial behavior, and then, of course, there could be a disciplinary proceeding. That's why I was referring to the Code of Judicial Ethics. And the discipline, maybe, Irina, I was not going into details. In case of a breach that is of a serious nature, there will be an investigator, then an independent panel comprised of international judges or some domestic judges that has nothing to do with any one of us. So it is a very, very proper and very thorough and quite severe outcome of such an investigation that will be conducted along the lines of a disciplinary proceedings. And then you asked me about Mr. Mustafa, 26 years. How can I make a comment when this case might come before the specialist chamber?
But still, the judgment was given.
No, just wait a minute. On the 14th of December, the appeals chamber, the appeals panel is going to render a judgment, but thereafter it is subject to a review if Mr. Mustafa would like to the specialist chamber of the Supreme Court. And I'm presiding over per virtue of law.
So, an example, it is a
Yes.
And the decision taken in Kosova Special.
I respect the decision taken by independent judges. I cannot make a comment. Then, if I would make a comment, if, of course, he's going to make a referral to the Supreme Court, you will have all reasons to ask that I be disqualified for this case. Having expressed an opinion, I can't. And I'm sorry if I in some way...
About the witnesses.
And about the witnesses?
Yeah. And the time frame of the judgment.
I told you about the witnesses. I can't, no, certainly no one knows. I think that I explained this to you. No one knows because these are protected witnesses, and this was the reason, most likely I told you that in this trial judgment, which is very short, and you can find it and read it. You have excellent, brilliant English. So, and it's a very short one. It is very clearly stated that these measures are undertaken because confidential information related to witnesses has been disseminated to individuals who are not entitled to have access to this information. So I myself, I don't know. And I was telling our younger colleagues, the students, I was telling them that it is the duty and within the authority of the registrar to deal with witness protection. And you might not believe me, I don't want to know who are the protected witnesses. I just want to be absolutely, or where they're relocated without knowing who they are. Just because I want to feel absolutely certain that even in my dreams, I didn't spell out the name, for example, of a country where they reside. So no one knows, and that is how it should be, by the way. It can be different. Yeah. Okay.
Edhe unë I kam 4-5 pyetje sekret për dhe tjerë.
Okay.
Dy të tretat po vlerësohet faktën kështu më ka thënë Fondi për të drejtën humanitare të procesit gjyqësor, po kanë qenë në me seanca private, pra apo cënohet me këta parimi të publicitetit.
Sorry, your name. What is your...
Ardit Kika.
Kika.
Kika, yes.
Okay, thank you, Mr. Kika.
Po, tjetra është për çështjen që është marrë një vendim paraprak apo vendim I përkohshëm lidhur me kushtet e paraburgimit, komunikimin me jashtë të tre prej të akuzuarve në rastin Thaçi dhe të tjerët. A mundeni me na tregu pse nuk është publikuar ky vendim I përkohshëm ditën që është marrë dhe është mbajtur I klasifikuar për 6 ditë nëse zgaboj. Pse nuk është publikuar me datën 17 kur është marrë ky vendim, por është publikuar me 23 nëse nuk E gaboj. Tjetra është a ka ndonjë paralajmërim apo ndonjë sinjal nga ana e prokurorisë që do të ushtroj akt akuz edhe lidhur me pengimin e administrimit të drejtësisë që I takojnë që ndërlidhen me kërkesën që e kanë parashtruar lidhur me komunikimin me jashtë në qendrën e paraburgimit për që ndërlidhet me tre të akuzuarit. Tjetra është edhe e fundit. Sa mujnë me shku, sa është maksimumi I dënimeve të gjykatës për krime lufte, krime kundër njerëzimit, edhe a merret parasysh precedenti I kaluar I ma herët e përmendet tribunalin për I Jugosllavin. A merret parasysh precedenti I kaluar në shqiptimin e dënimeve që ka të bëjë me dënimet që janë dhënë lidhur me krimet e luftës të kryera në territorin e Kosovës. Faleminderit. Më tregoni nëse s'keni pas diçka të qartë.
If it is not clear, certainly I will ask you. Yes.
May I just suggest, because we're running a little bit out of time,
No, let us. I'm here.
I'm just saying that we take the nothing.
And
there, and then
the gentleman has been willing also. Yes.
Arjan Hajdari, gazetar në televizionin Botë.
What is your name?
Arjan.
Hajdari.
Paka shumë që shtu.
Okay.
E ka shqetu deri tash gjykata lirimin e parakoshur për Nasim Haradinajn, marrë parasysh që deri tash është gjeru Hysni Lucati, i cili është arrestuar paka shumë në të njëjtën kohë me Nasim Haradinajn, dhe që janë arrestuar në të njëjtën kohë dhe përballeshin paka shumë me të njëjtat akuza.
Yeah. Yes, and your name is Mr.
Jam Sulejman Sulejmani.
Sulejman.
Gazetar në televizionin Dukazini. Shumica pyetjeve u bën, por pyetja vetëm me cilën e kam për juve është nëse do të shqyrtohet një kërkesë, përmendi më herët kolegu Besian Beha, që është bërë nga ana e mbrojtjes së ish-kryetarëve të UÇK-s, që disa prej dëshmitarëve për shkak të moshës që të dëgjohen më herët, do të merren në pyetje dhe të nga grupi gjykues më herët, pra të dëgjohen sesa disa prej dëshmitarëve që po dëgjohen deri më tani të prokurorisë. E dim që tashmë dëshmitarët kryesorë të prokurorisë besi janë dëgjuar, për shembull është përmendur që 12 dëshmitarët e parë janë shumë të rëndësishëm dhe ka ndonjë mundësi që kjo kërkesë e mbrojtjes të shqyrtohet për më vonë, do thotë, që këta dëshmitarë të dëgjohen më herët para se vazhdojmë me dëgjimin e dëshmitarëve të tjerë të zyrës së prokurorit të specializuar. Kjo është pyetja parë.
Well, I will start with the last question, and then I will move up to your question. Now, well, first of all, the procedure provides that the prosecutor has to finish his case. So, however, this does not make impossible for the judges. Well, I'm just contemplating whether if I would be approached at the beginning or in the middle of the prosecutor's case with such a request, whether I will make as a matter of an exception. I don't know. I will give it a thought at least. However, after the prosecutor finishes the case, the defense has a number of options. The defense might decide at all not to proceed with its case, but just to ask for one of the 3 summary proceedings that we introduced into rules of procedure and evidence with the view to expedite proceedings. And one of them is no case to answer. Based on the evidence, the defense would seize the bench of the judges, asking them just to take a decision that actually this case is so weak, not supported by evidence, and we just have to put an end to this case. So we don't know whether the defense is... So now, when you ask the question, I was already contemplating if I'm going to be approached in the courtroom with such a request, if I'm a sitting judge on a case before the basic court, what I would do. I will not be very much positive, maybe, because no one knows where this case is going to go. No one. There could be also an option that the defense would ask for either of the other 2 admission of guilt, which is not going to happen because it depends, and already everyone brought to account said, pronounced to consider himself not liable, innocent, but maybe a plea agreement. So this is the 3rd summary proceedings. I don't know what is going to happen. Judges might consider it, depending on how they see the age, how important a witness is. There could always be creativity in the judicial decision making. So, but I just, as a lawyer, I was contemplating in your presence. But I cannot say what they will do. That is my response, Mr. Suleiman. Then to you, Mr. Haidori, it is true, yes. It is true that Mr. Guzzati and Mr. Haradinaj have been arrested on the same day for the same crimes and so on. However, they are individuals. They have their own behavior. And it was, of course, in my decision, with very, very minor reductions for Mr. Haradinaj, I convened hearing with them. For me, it was very, very important, not only before taking the decision, it was very important that I face them and I hear from them. I wanted to see how they feel about what is to follow, about the offenses for which they have been convicted. I didn't do this in a courtroom. I didn't do this with public. I wanted just me and them. Of course, the defense counsel was there, the interpreter, and so on and so forth. But I told, and it was separate for each of them. These are already separate individuals, and they have to be dealt with separately. And I was asking them, just disregard the rest, consider me and you. I want you to tell me this and that. Based on their answers, and importantly, on the disciplinary record. Mr. Guzzati doesn't have any disciplinary record. Mr. Haradinaj does, with 3. So now let us see. I'm expecting to see a report on this. So, but it was, you know, in our profession, we approach everyone individually. Even when there is a co-perpetration, as was, for example, let us assume in this case, or in the big case, the destiny of everyone will be decided separately. They all might be acquitted. They might be convicted, but everyone differently so. And this is the magic of this profession. We don't know. I can't tell you. But as I was taking the decision, that is my explanation, which is absolutely 100% what is in the decisions. Now, Mr. Kika, first of all, about the private sessions. 2/3 are private sessions. Well, but I mentioned a while ago that in a lot of, with regard to a lot of hearings, the defense was also willing to go into private sessions. So it shouldn't be attributed only to the judges that they are as, oh, Mr. Beha, he left, but he might have had other questions. Okay, my greetings to him. So, actually, there was also recently several witnesses, I don't remember, maybe 8 witnesses.
Yeah.
Yes, oh, you see, thank you so much, you're following, and that is but that's very much appreciated. That makes me very, very pleased. Thank you for helping me as well with the number. The panel said no to the witnesses. You're going just to speak out, not in private session, just because there should be an end. However, it is decided on a case-by-case basis by the judges. And I'm telling you, with all the responsibility that every one of them puts into what they're doing, every single minute. So it was not, of course, when it's in private session, I myself also cannot follow. And I'm telling you, as a lawyer, it's interesting. Every case is different. Every day is different. Then about the indictment, no one knows. And here I would refer you to the case where there was a suspect. I don't remember the name of. It was a gentleman who has been investigated in the course of 1-2 years. And this is Rule 47. And I was very, very much happy to have this rule. It was suggested during our discussions by one of our colleagues, and I have implemented this in my domestic system for the investigations. And it was
investigated 4 years.
How many years?
4 years.
I think it was 2, but okay, maybe I'm mistaken. And it was closed, the investigation. So,
More than 2 years.
no, we're not discussing now his case. There was no sufficient evidence, and it was, yes. My point is different, Rina. My point is that the prosecutor arrested Mr. Bakhtiari and Mr. Yanusi. Yes, but this doesn't mean that in the course of investigation that he's conducting, now she, Miss West, that she's going to have sufficient evidence to press charges and to come with an indictment. That's why I was referring to this case, because Mr. Laichi was investigated, as you say, for years, and at the end of the day, there was no evidence. This could be exactly the same. Here, of course, the issue will be different, because they're arrested, and no one is going to wait for so much time.
We have 2 more questions unanswered about classification.
Yes.
Yes, 2 more questions. I think you haven't answered about classification of the decisions.
Kilai, yes.
Sorry.
Sorry.
I think you have 2 questions unanswered.
Yes.
First is,
please do tell me, remind me.
On classification of the decision on detention of the 3 accused, the conditions of detention, communications with the outside world.
The recent one?
The recent one, why it was classified, and when we can get a new decision within the merits of the...
Let me immediately respond so that I do not forget. First of all, no, it is public.
No, but I think he's asking why was it not immediately, why it was issued on the 17th, but the public redacted.
Well, would you tell me what was the 17th?
Yeah.
Which date was?
It was taken, the decision.
Yes. No. Which date of the week?
27.
Here is the response. Thank you very much. It was issued on Friday. And judges were away from the court, and they had to assemble together as soon as they came, and only then they rendered the judgment. That is a very simple reason. That's why I was asking which day of the weeks the 17th was, because I know how much focused the judges in both panels, of course, on this one as well, that I immediately started, this should have been somewhere around Thursday, Friday. It is, thank you very much. That is so simple. There is no conspiracy. Why should the judges hide this?
I didn't understand your response.
The decision...
So why classify it?
I think he's asking why the original version was confidential, why the public redacted version was only
But the
issued
public
several days
redacted
later.
version had only some, and reductions are not just you take the decision and, oh, let me redact this name. No. You have to study on the basis of what you're receiving. You have to study your judgment and to see whether there is some information that is not just confined to a name, that would still disclose the protected witness. And I shall give you an example. For example, in one of the cases that I used to have before the ICC, the common plan to commit crimes was discussed amongst the 3. One was a witness, a valuable witness insider. It was not sufficient to redact his name, because if we wouldn't have redacted the place and timing of the meeting, of course, he immediately is known to those who are brought to account. I'm just giving this example for you to know that it is not something that you just take and, oh, here there are some names, and we just redact and that is it. No, it is a decision that you take with all the responsibility, what you will leave in order to inform the public and what you're going to redact, but to protect people. That is it.
That day we had.
And that took this time.
We didn't have any like notification from the court that a decision was taken on that issue.
But isn't this a decision on the page?
It is.
Yes.
And it was published after like 4 days or something.
Yes.
And the last question was about the maximum.
Yes. Thank you very much for reminding me. Although I wrote here immediately the response.
If you take into consideration the former precedents on.
Well, first of all, our law provides for imprisonment up the most severe one being life imprisonment. And of course, judges are going to be guided also by the Kosovo Criminal Code. And judges could take into consideration, which is not at all mandatory, the approaches with other institutions, not confined only to one. But the main framework within which such a decision has to be taken is our law, which provides imprisonment, which could be up to life, and of course the Kosovo Criminal Code.
Still, seriously, it's not anywhere in our criminal code.
So it was decided, yes, the lady.
So let's take one, I think.
Yes.
In Albania.
Okay. Let me reflect your name, please.
Altina Marmulaku. Zonja Trendafilova.
What is the name?
Altina Marmulaku.
Altina. Thank you, Altina.
Altina Post.
Ja.
Zonja Trendafilova, gjatë muajit tetor kemi pasur disa bastise në Kosovë. Ju I quajtët kontrole, ju referuat si kontrole, desha të informuar nga ana juaj se a do të vazhdojnë që të ketë bastise sërish në Kosovë në vendbanimet caktuara.
Well, as I told Mr. Kole. As I told Mr. Kole, well, the proper legal terminology is searches, not raids. There are no raids. I don't know why everywhere I read about raids, but the proper is searches. Whether there will be more, that was your question?
Yes.
That I don't know.
Yes.
That I don't know, Alina. I don't know because you know that under the legal framework and following, of course, the structure of the Kosovo judiciary and the office of the prosecutor, we are two different institutions. We don't communicate. That is the only communication that I was referring to. The only communication when I need in order to do my job as efficiently as possible, just to know that we are going to be seized. That's it. But I can never ask the prosecutor, by the way, I'm not interested and I don't want to know. Because it is equally important that you feel that you're doing the right thing and you feel that you're really respecting the oath that we all give before taking over our duties. And what is the purpose for me to know? The prosecutor might change tomorrow. What am I going to do? I'm not a prosecutor, and I don't need. Maybe there could be searches and seizures, I don't know. This came very unexpected to me as well. I just realized following actually, I think, the media reports here from Kosovo, because Michael, together with his colleagues, as I said, is providing in the morning and in the late hours of the day information about everything that is related to the case. And it is important, very important for us, because we have to see where there is not sufficient clarity. We have also to make certain that it is necessary to meet people, to meet representatives of the civil society, to meet NGOs, to meet young lawyers, and not only lawyers, students from all over the country. So that's why we follow. And I'm sorry.
Luljeta dhe Molli për qendrës kosovare për studimet gjinore. Lule.
Kelmendi.
Luljeta dhe Molli.
Demoli. Because there is a journalist, no. Mr. Kelmendi, Adriatic?
Adriatic.
Yes, a very good one. He was very well prepared, very well. His father is a lawyer, because I was asking him after the interview, I said, but you are so perfectly prepared. He said, well, I studied, but also I had my personal advisor, my father. So many greetings to Mr. Kelmendi.
I am Luljeta Demole, but it's okay. Deshta me shtu një pyetje, falem pak për rekomandimet ose çështjet që i merrni për drejtat e njerëzit nga avokati i popullit. Këshillat, interesimi jam ose pyetja ime ka të bëjë me si të kuptoj pak më shumë kur një rekomandim i avokatit të popullit kalon tek ju. Ku e kuptojmë, ka ndaj raport, apo qysh i merrni, ku mund të kuptojmë pak më shumë, në çfarë platforme. Po ashtu, a do të takoni edhe avokatin e popullit në këtë vizitën e juaj në Kosovë, edhe sa i përket raportimet ose rekomandimeve të grevjes që monitoron konventin e Istanbulit në Kosovë, keni marrë ndaj koment, apo si merrni rekomandimet e këtij nivelit, kur është fjala vetëm për drejtat e njerëzit. Do të thotë rekomandimet e avokatit të popullit ose raportet e tij, kur e kuptojmë na që ju i keni marrë ose nuk i keni marrë në çfarë platforme. Edhe ato të atakoni avokatin e popullit në Kosovë.
Well, thank you, Ms. Demoli. First of all, the ombudsperson, as I said, indeed is absolutely independent. He's not reporting to any one of us. He's doing his job himself based on complaints that he would receive. The results of the complaints, his decisions, are on the website. I think that for this year there were two reports by Mr. Spera, who is the ombudsperson. He doesn't inform me because everything is on the website, and he doesn't have this duty to inform me. However, if dealing with the complaint, he would detect some inappropriateness within the specialist chambers or with the specialist prosecutor's office, then his findings and recommendations will be communicated to me for the chambers and to the specialist prosecutor for the specialist prosecutor's office. That is the only way that I'm not informing him about my visits. Well, we are not dependent on each other. No one has the duty to report. Why should I report to him? He can read. We are going to make a press release. I'm certain he reads also here the media reflections on this visit. Of course, I very much regret about this protest outside. People, much better let them come and ask any question. That's the whole purpose. But I don't know. why they do it. There were two young gentlemen that came with whistles. They were very nice. I invited them to stay, but they left. So maybe just that is their right to protest, the way they feel. Everyone chooses the way to exercise his or her rights. That's it. But I would have preferred that they come. So, other questions?
Yeah, we have this event at 5
yes.
now. We have the other meeting now in 5-10 minutes.
Okay.
So but,
yes. Just a minute. Yes.
Përktimi online nuk ka funksionu, kështu që vetë kam ditë një mbretje prej disa prej kolegëve që jam këtu pjesëmarrës që përktimi s'ka funksionu edhe online. S'po di nëse do të jenë ndoshta të shpejtë në ofrimin e përktimit edhe për ata të cilët s'kanë qenë pjesëmarrës, por kanë vendosur që këtë takim ta përcjellin online. Për shkak se kanë disa kolegë që u ankuan që s'kanë pasur mundësi të bëjnë lajme për eventin për shkak se s'ka pasur përktim edhe në YouTube, në kanalin tuaj në YouTube.
There was no translation online, so I couldn't understand your question.
Are you speaking about the YouTube? Yeah. So because this is being live streamed now on YouTube, there wasn't the technical possibility to live stream simultaneously. So what is being live streamed is the floor version. Whatever language anyone is speaking is there. I have a Dropbox here address. When the single language versions are made, they'll be available at this Dropbox along with any photographs from the event. On YouTube right now, after the event is over, automatically there will be a recording, but of the floor version. That's just the way the streaming works through YouTube. So
thank you. I wouldn't have been able to explain, to give an no. Thank you very much. I don't know how it works. So very much grateful. So was this the question? Yes. Mr. Suleiman, we have the same name in Bulgarian. Yes, of course. So thank you very much. I hope that I could give a response to your questions. And this is exactly what I would say to you, Rina, in person, confidentially, or in public. So there can't be different answers to one and the same question. So things are just, and they have to be open, honest, and without any limitations. When I cannot say something, I just notify you. But thank you very much. Have a very good evening and best for the upcoming new year. Let us hope. Yes, let us hope that things will be fine. Thank you very much.